Good afternoon, Elder Justice Warriors. We are so happy to have you joining us today for our 7th edition of the Elder Justice Lunch and Learn series. And we are excited to continue learning in December. So thank you so much for being here. My name is Nicole Howell. I'm the Executive Director for Ombudsman Services of Contra Costa, Solano, and Alameda. And I look forward to learning with you today. For those of you who return to our little community, you will know that it is a highly interactive event. And we like to start off by jumping on the chat, and you can write your name and kind of where you're from and what you do. Tell us which section of the elder justice community where you work. And then as we work throughout the process today and something pings for you that Miriam says, I encourage you to drop it in the Q&A section for your chat. We are going to have time at the end to answer questions. And so we want to make sure it's an interactive process, and we want to hear your voice in this. As you know, accessibility is important to us, and we have closed captioning available and ASL interpretation thankfully through California Department of Social Services. So if you need those functions, please set those up, and we are so glad you're here. Normally we meet on the 3rd Thursday of every month, but this month we're a little bit early to accommodate for the holiday. We'll return to our normal 3rd Thursday next month. But while we're here, I want to take a moment and wish everyone a happy Hanukkah who celebrates. I hope this kicks off a season of light and rest for you and your family. This webinar is provided to you by my organization, along with a plethora of valuable planning partners. Our sponsor is Kaiser Permanente, and our planning partners, California Department of Social Services, California Commission on Aging, California Long-Term Care Ombudsman Association, the Office of the Long-Term Care Ombudsman, California Department of Aging, and California State Associations of PAPGPC. Thank you to all of our planning partners and our sponsors. And today I am thrilled to bring you Mariam El-menshawi, an expert in so many issues, but she's also the director of McGeorge School of Law, the Victims of Crime Resource Center. She's the managing attorney for the VCRC Legal Center, which provides holistic legal services to victim crimes. And Mariam is really knowledgeable in victims' rights, and she's going to bring to that today so we can understand how we can better work with our victims of crime who are older adults and individuals who experience disabilities. So with that, I am pleased to turn the platform over to Mariam. Mariam, thanks so much for being with us today. We look forward to learning with you.
Good morning. Thank you, Nicole, for the very warm welcome. And good morning, everybody. I'm really excited to be here to share information about victims' rights with everybody. Can everybody see my camera? All right, PowerPoint? Perfect. It looks like everybody can. So today we're going to be talking about how you guys can support crime victims in California and how we can really work together to make victims' rights a reality. Before we get going this morning, I did want to let you know that we are going to be talking about some scenarios that do talk about violence and or assaults, which may be triggering for survivors. So if you need to step away, please, I encourage you to take care of yourself first. So please feel free to step away if you need at any time. Before we get moving into the specifics on victims' rights, I kind of wanted to take us back a little bit and talk about the historical context of victims' rights in the United States, because I think it helps give us some perspective to appreciate how far we've come as a society. So back in colonial times, victims used to actually prosecute their own cases. There was no uniform law enforcement or prosecutorial system. So anytime a crime would happen, the victim would go out, they would investigate, they would put money out for rewards for more information, they would hire a judge or find a judge who would listen to the case and hire an attorney to help represent them. And they were there front and center in the criminal case. As time went on, states were like, hey, you know, we have an interest in protecting our citizens. We don't want criminals running rampant in our communities. So states started taking over the prosecutorial and law enforcement role. Unfortunately, when that happened, victims kind of got pushed out of the process. So they went from being front and center in the criminal justice system as they sought justice, and they got pushed out and marginalized to the point that in dicta, there's a US Supreme Court case that states that a victim doesn't have an interest to be in the courtroom while their criminal case is being tried. So that mentality was really shocking to a lot of victims who were impacted by crime and victim advocates, and they fought long and hard to make sure that victims have rights that allow them to be there in court to get information. And that was really the start of the victims' rights movement. And during the 1970s, a lot of states were passing legislation for victims' rights and into the 1980s. And that takes us to a time when Marsy Nicholas was a senior at UC Santa Barbara. She was studying to become a special education teacher, and she was a senior about to graduate. Unfortunately, she was in a bad dating relationship. She decided to break off that relationship, and her ex-boyfriend did not take the breakup so well. He had been stalking her and harassing her prior to her visiting her family that Thanksgiving break. She got a call from him on November 30th, 1983, where he said he was going to kill himself if she doesn't come to see him. And being the kind-hearted person that Marsy was, she left her family's home late that night, drove to his house, and as she proceeded to walk towards his doorstep, he shot her. Everybody knew who did it. He was arrested, and her family was there for arraignment a few days later, and they saw him being taken away in handcuffs. A few days after that, Marsy's family laid her to rest. And on their drive home, they decided to stop and pick up some groceries from the grocery store. And as Marsy's mom entered the grocery store, guess who was walking out? It was the killer. He was released on bail, and nobody decided to let them know that there was a bail hearing. So they had no idea that the courts were considering releasing him, and he in fact was released. And he wasn't walking out of that grocery store ashamed or embarrassed of what he had done. No, he was actually taunting and harassing the family. So her family was really appalled that at the same time that all the states were passing statutes giving victims participation rights, that those rights were just not strong enough. So they, along with victim advocates, fought long and hard to get victims' rights in California in the Constitution here in our state. And from 1983 to 2008, they lobbied, they worked hard, and in 2008, Marsy's Law was passed in California, giving victims 17 rights. So just like criminal defendants have rights, in California, victims have rights in the California Constitution as well, and 17 of those rights. And we'll be talking about those rights as we go through. And there's actually a move across the whole United States to get similar legislation passed in various states to ensure that victims who didn't ask to be part of the criminal justice process, who are propelled into the system, have rights that ensure that they have a meaningful voice, a meaningful participation in the process. And we have about 36 or so states that have passed similar legislation with the hope that eventually victims will have constitutional rights at the federal level as well. So why is it important to include victims as part of our criminal justice system? Well, first of all, it's fair, right? We talked about how nobody asked to be a victim of a crime. Victims are propelled into this process, and a lot of times they are not prepared to deal with a lot of what has to happen from that point forward. They're not familiar with the players, they're not familiar with the process. So it's just fair to give them rights that will allow them to have that meaningful participation. Additionally, what we have learned about trauma is that victims can suffer secondary victimization by the way that they're treated in the criminal justice system. Unfortunately, what we have seen is that victims end up getting re-victimized by the system because they are excluded, they're not given information, their input is not taken into consideration, they're not made to feel like they're part of that process, which makes them feel like they were a victim not only of the crime, but also of the process. So they end up at the end of the case feeling re-victimized, feeling more traumatized than they did at the outset of the case. When we give victims rights, when we make sure that those rights are respected and enforced, victims end up feeling empowered, and they end up feeling like they can move on with their lives after this crime had happened. And just being involved in the criminal justice process is very traumatic, right? Like I said, nobody asked to be a victim of a crime. So when you are a victim of a crime, there is shock that you endure first. And then, you contact the police, or the police are contacted by a neighbor, and you have to tell your story. And then the investigators call you and you have to tell your story again. So this constant repetition of the story elicits a lot of emotions by the victim, and victims end up getting a lot of PTSD and other mental health symptoms from just the trauma of being a victim and then having to repeat it and go through the process of retelling over and over again, eventually being in the same courtroom as the offender. So just being involved in the system can cause a lot of trauma, and that's why it's really important for each and every one of us to make sure that victims have respected rights as they're going through this process, so that they feel empowered and they know what they have to do and what they can say no to as they're going through the process. So you may be asking yourself, well, what is justice? What are victims looking for? And the short answer is really, it varies. Each victim wants something different. Each victim sees something different as justice to them. Some victims want nothing to do with a criminal case. Other victims want to be there front and center at all times during the case. So it's important for us to understand what our clients want as they're going through this process, and to make sure that they have the knowledge of what rights they have to make sure that they get to participate as much or as little as they want as they're going through this process. But in general, victims want to be treated respectfully by people in the system. They want fair treatment during the proceedings, so they want to see that the rights are being respected, just like the defendant's rights are being respected, and they want to feel like they have a voice and choice in participation. And not doing that for victims, ignoring the rights, not listening to them, really has system-wide impacts on our states, right? On the safety of our state, because victims are going to be less likely to contact the police if they feel like they are being left out, if they feel like they're not being taken seriously, if they feel like they're not getting information about what's happening in the case. They're going to lose trust in the system. They may completely disengage. And then they're going to tell their friend, hey, if the crime happens, don't call the police. That's just going to cause you a lot of heartache. So we want to avoid these system-wide negative impacts of excluding victims. And we want to make sure that we're including them and empowering them with information about their rights. And it can be a very scary thing, right, to call the police. So we're going to go ahead and launch our first poll, which is going to ask you what concerns might some of your clients have when they are deciding whether or not to call law enforcement. And you may be able to only choose one, but I know some of you may have more in mind. But go ahead and we'll go through the answers. But these are some of the things that victims may consider before contacting the police. And sometimes the police get contacted by somebody other than the victim, right? Like a neighbor. So we can, hopefully everybody had a chance to vote, and we will be closing the poll here in just a few seconds and launching the results. Perfect. So every single one of these was tagged by the participants as a reason that victims are concerned about contacting the criminal justice system, including privacy concerns, right? And we're going to talk about that later in the presentation. Stigma or community shame. A lot of victims feel like they're going to be looked upon negatively by their family, by their friends, by their neighbors. Loss of independence is a huge one, right? Well, you can't take care of your own safety, and others. So thank you guys for participating. And these are all important for us to keep in mind when victims are part of the process, because at that point they have lost that control of deciding whether or not to participate in the criminal justice system. So before we start talking about Marsy's law and why it's important to make sure that victims are aware of them, I want to do a quick poll, another quick poll, and ask you guys how many of you guys have heard of other types of rights. So if we can go ahead and launch our second poll, I want to ask you guys about Miranda rights. How many of you guys here have either heard of Miranda rights or can actually recite at least part of it? So it's a yes, I can recite it. Yes, I've heard of it, but can't recite even part of it, or no, I am not familiar with it. And we'll just give you guys another few seconds here to vote. And I think it's important for us to be thinking about what types of rights we're familiar with and what types of rights we aren't familiar with, and really consider the whys. Why is that? Can we go ahead and close the poll and let's see the results? All right, perfect. So only 3% of you guys are not familiar with Marsy's Law, which is with Miranda rights, which is not shocking. The majority of folks in the United States are familiar with Miranda rights. The majority of you guys, 53%, actually can recite at least part of it. And that's been our experience at the Victims of Crime Resource Center, even with young kids. Young kids are able to recite part of Miranda rights. And if you think about why that is, it's because it's part of our culture, right? It's on TV. We hear about it and learn about it in our schools. But when you think about Marsy's Law, and if we did a same poll for Marsy's Law, the results would be drastically different. Not only aren't our students taught about Marsy's Law, our law students aren't taught about Marsy's Law, but our service providers, prosecutors and judges a lot of times aren't familiar with Marsy's Law to the extent that these rights are meaningful for victims. It's not part of our culture, right? And that's why it's important for each and every one of us to make sure that we're educated and that we educate others about these rights. When I was in law school, I took all of the criminal law type classes that I could take, and never did I hear about Marsy's Law. I didn't hear about Marsy's Law until I started working at the Victim Center. And these are constitutional rights, right, that you expect your attorneys to know about. But unfortunately, that's not the case. So you can't rely on other people's knowledge of these rights. It's really up to each and every one of you to make sure that you're notifying your clients and the victims that you're working with about these rights. So with that being said, let's go ahead and delve into these rights. So the definition of victim under Marsy's Law is very expansive. It not only includes the direct victim, so the person that was directly impacted by the crime, the person that suffered the assault or what have you, but it also includes their parents, children, siblings, or guardians. And just as a side note, I am going to go through a ton of material, but you are going to be receiving a copy of these slides with all this information. So if I'm going a little quickly, it's just to make sure that we finish on time, but you'll have a copy of all these slides. So with that being said, the definition is very expansive, and victims have a constitutional right to be notified of these rights. And that's one of the 17 rights under Marsy's Law. But I want to unpackage this a little bit to really think about, what does notification mean? And specifically, what does meaningful notification mean? So it's been our experience at the Victims of Crime Resource Center, we are a statewide agency, is that a lot of victims aren't receiving their Marsy's Law card, or aren't being told, hey, here are the rights that you have. But even in the best case scenarios, for those counties that are actually handing victims their Marsy's Law card when they first meet with victims, victims are given a copy of this card and it's written in legalese, right? So it's actually the constitutional text pasted on a piece of paper handed to victims. So if I'm a victim that has just gone through trauma and I get this paper with legalese written on it, it's not going to be very clear to me, A, what this means, B, is it asking me, do I have to take any action to make these rights happen? Or C, who I can go to for help. So it's really important to know that even if victims get this card, a lot of times they don't understand what these rights specifically are and what steps they have to take, if any, to make these request these rights if need be. Victims also have a general due process right to be treated with fairness and respect by everybody in the process. Victims have the right to protection, right? A lot of times our clients, if they are a victim of a crime, they're afraid of the perpetrator, right? Whether that person's a family member or a stranger. They're afraid they have to go through the process. They're getting subpoenas to be in court. They're afraid to be there. So Marsy's Law does provide protection, and the district attorney's office can issue criminal protective orders to protect the victim. We can do things like making sure that victims feel safe when they're in the courtroom. So there are things that we can do to make this protection right meaningful. One of the programs that California has that does provide some protection for victim is a Safe at Home program. It's an address confidentiality program, and I have information here on that program, but if you have time after this presentation, please go ahead and Google this program, the Safe at Home program. It's run by the California Secretary of the State's office. It does provide a free PO box for victims, including victims of elder abuse. So this program is really critical for a lot of victims to make sure that their address is confidential. Victims can do confidential name changes. They can do confidential voter registration and other things. So please check this program out, as it's a free program by the state for victims of certain crimes. Victims also have the right to have their safety considered when the judge is setting bail and release conditions. And if you think about Marsy's case, the family wasn't even told that there was a bail hearing. So victims have the right to be notified of these hearings, but they have to request that right to get notified. And they also have the right to provide input and have the judge consider their safety before setting the inmate out on bail or other release conditions. When people think about a victim of a crime, and if you are unfortunate enough to be a victim of a crime, you wouldn't expect to give up all of your right to privacy, right? That's not something that you think about when you call 911 if you were a victim of an assault or another crime. And Marsy's law does protect the disclosure of confidential information. However, a lot of times what happens when victims are part of the system, their records are sought, right? And if we think about what records are sought, a lot of different records can be sought as part of the criminal case. And some of these records can be subpoenaed by the prosecutor, and other records can be subpoenaed by the defense attorney. So it's really important to think about these records and what it would mean. And I want each and every one of you to think, would you be comfortable if your Google searches from the past year were subpoenaed? Right? Not that you're doing anything wrong online, but there's a certain expectation of privacy with things that you do on a daily basis. And a lot of times these subpoenas end up being a fishing expedition by the defense attorney trying to poke holes at the victim's credibility. And they can be used as a tool for intimidation and harassment. And victims aren't always told that these records are being sought, right? So if my mental health records are being subpoenaed, that subpoena is going to go to my mental health provider, not necessarily, and I won't necessarily be notified of it. So it's important to keep that in mind as well as we think about victims participating in the process, and how important it is to let them know, hey, you have the right to protect some of these records. And of course, you know, as we look at some of these records, like the medical records are protected. Sometimes a defense attorney does have a right to them and they have a justification for why they need them, but other times not. So the victim can challenge some of these subpoenas either through the DA or through their own victim's rights attorney. Victims also, like I said at the beginning of this presentation, get contacted, right, by a lot of parties in the criminal case. There's so many different players in the criminal justice system, and a victim that's all of a sudden part of this process isn't always familiar with who the players are. Victims under Marsy's law have the right to refuse to communicate with a defense attorney or anybody acting on behalf of that defense attorney. Unfortunately, the defense attorney doesn't always identify his or herself as the defense attorney. So a lot of times what we see is that clients will end up being tricked into speaking with a defense attorney or a investigator working with the defense counsel. And I'll talk quickly about how some of these tactics are used, just so it can be on your radar. One of them is a private number. So a lot of victims going through the process get contacted by either their victim advocate at the district attorney or the DA overseeing the case, and they'll call from a blocked number. So the victim knows anytime I see a blocked number, it's likely going to be somebody from the DA's office. So the defense attorneys have picked up on this, and what they have started doing in some counties is just blocking their number, calling the victim and saying, hi, I'm calling you from the DA's office. And by DA, they mean defense attorney, not district attorney. Or, hi, I'm calling you from the PD's office. And the victim would think PD, okay, that's police department, when they actually mean public defender. So the victims wouldn't know, okay, I should be asking more questions to make sure that I'm talking to the right person. So they will go ahead and divulge a lot of information to them when they have a constitutional right, as we said, to just completely refuse to speak to them. Other tactics being used are kind of threatening or intimidating tactics. So you need to answer these questions. We need this for the criminal case. So somebody calls them and is pretty aggressive. I've even had defense investigators show up at victims' doors. So, you know, catching them completely off guard. So it's important to be aware of these tactics because it can have an impact not only on the criminal case, but also on the victim's feeling of safety and ultimate vulnerability in this process. Victims have the right to speedy resolution of the case, just like a criminal defendant has the right. Victims have that right too. And a lot of times victims are frustrated because they feel like the case is, you know, being continued over and over again, and this case is going on forever, when all they want is just, you know, final judgment in the case and conclusion so they can move on with their life. They don't want to be sitting there waiting for the subpoena. They don't want to be sitting there waiting to give their victim impact statement, you know, next month, and then it gets continued the month after, etc. So of course, we want to make sure that the process is fair. So sometimes there are valid reasons for continuances, but if the victim feels like these reasons aren't valid, they have the right to voice their opinion to the court, and also to file motions either on their own with their own victims counsel or through the district attorney if the district attorney is comfortable doing that. Victims also have the right to provide input when probation is putting together the pre-sentence report. So we're going to do another poll, and this is about financial assistance. So when we think about crimes and how victims are impacted, not only the emotional toll on victims, there's also a huge financial toll on victims, right? And that can include medical expenses, mental health expenses. So when criminal charges are filed, is that the point at which victims are eligible for compensation? Or can they apply before that? Or do they have to wait until there's a conclusion of the criminal case and the person is convicted for them to apply for victim compensation? And it's important to be familiar with the various types of financial assistance for victims, because like I said, victims need financial assistance. And a lot of times it can cost victims hundreds of thousands of dollars for being a victim of a crime. And, you know, so I've actually had clients that have ended up going bankrupt because of medical expenses that they've ended up having to face because of the crime. So let's go ahead and look at the results of the poll. The majority of people are not sure, which is very typical for most service providers across California. Some people said yes, 15%, and some people said no. So actually for victim compensation, there does not have to be criminal charges. And a lot of times there are some scenarios where police don't even have to be contacted. And it's important to distinguish between victim compensation and victim restitution. Victim restitution is a right under Marsy's law. If a victim suffers any out-of-pocket expenses as a result of criminal activity, victims have the right to secure full restitution from the offender. So as long as there's a conviction and the victim suffered losses, restitution is mandatory. Restitution is typically set at sentencing. There is no statutory deadline, but unfortunately what we see happening a lot of times is this TBD. Victims aren't notified of their right to get a restitution order, so they get set as TBD or to be determined, which causes a big problem for victims because it's up to them then to, after the case has concluded, to try to get this amount set. And these are some of the losses that can be included under restitution. And if you want more information, please give us a call. If there is no criminal conviction, and even in some scenarios, if police aren't contacted, victims can still get compensation. So restitution is money that victims can, in order for monetary damages that victims can get as part of a criminal case and a conviction. Compensation is very different. Like I said, victims don't have to sometimes even have contacted the police, and charges don't have to be filed. And the California Victim Compensation Board does reimburse victims for up to $70,000 for certain expenses. And the victim can apply for compensation as soon as the crime happens. They'll want a copy usually of a police report if one is needed, and other types of verifying information, but it's up to $70,000. And I have a few slides in here that that you'll get later about victim compensation, but it really is huge for victims to have access to these funds, and they don't have to pay the CalVCB funds back. It's run by the state, so just keep that in mind. And to qualify for compensation, you have to be a victim of a crime that involves some type of a threat of physical injury or actual physical injury. So unfortunately, like financial crimes alone or property crimes alone won't qualify. But if you have any questions about CalVCB, please give us a call at the Victims of Crime Resource Center, and we'll be happy to provide you with more information about how you can apply for that program or how you can apply for the Safe at Home program for your clients as well. Another one of these automatic rights that victims have under Marsy's law is the prompt return of property. So sometimes when crimes happen, items are collected as evidence, and you know, sometimes victims don't get it back right away under Marsy's law. You know, when it's no longer needed as evidence, they do have the constitutional right to have it returned to them. Victims also have an automatic right to have their safety considered during parole or other post-judgment release decisions. This is an automatic right, but unfortunately the victim actually has to take a step to request it. And that is the CDCR form 1707. And that's the California Department of Corrections. They have a form on their website, which takes like 5 minutes to fill out, but that's how the victim actually gets in contact with that agency that, you know, helps manage victim services for the Board of Parole Hearings and CDCR. So although victims have the right to have their safety considered, unless they contact CDCR, they are not going to get this service. So make sure that if you know of a victim, or if you're working with a victim who was involved in a crime and that person was convicted and sent to prison, make sure and have them contact us or contact the CDCR Victim Services to fill out that form. So all of the rights that I've talked about so far have been automatic, and we are going to launch another poll here asking you about these next set of rights that have to be requested. And the term upon request actually shows up on the Marsy's Law card. So I want you to think about, okay, so if I get a card and it says, you know, I have this right upon request, do they give me some guidance as to what upon request means? True or false? So I'll just give you guys just a few more seconds here to fill that out. And then we will go ahead and talk about whether or not that's true. So let's go ahead and close this poll and look at the results. So the majority of you guys, 63%, think that there are guidelines for requesting the rights, which makes sense, right? Logically thinking, if I have a right that has to be requested, I'm going to be given some guidance. Unfortunately, that's not the case. Most counties don't have any guidance at all about how victims should be making those requests, who I should be making the request to. Do I email my advocate? Do I call the DA? Do I go in front of the judge? Do I have to submit it in writing? When do I have to do it? Is it at the outset of the case or in the middle of the case? None of that guidance is there. So we put together a set of best practices on how these rights should be requested because there is no uniform guidance out there. So we recommend that victims, and that you tell the victims that you're working with to notify both the victim advocate at the district attorney's office and the DA who's overseeing the case that they want their rights requested, they want to participate, and to do so at the outset of the case. To do so in writing, and it's important to do that because sometimes when we communicate with others through the phone, you know, things can be misunderstood. So it's important to have that paper trail so that if, you know, God forbid your right is violated, that you have a way to possibly get it corrected. And make sure that it's in the DA's file so that, for example, you know, sometimes the cases move very fast. So you'll have a plea offered to the defendant agrees to it, and then you have sentencing a few hours later, and the victim, for example, had requested to be notified of the sentencing because they want to read their victim impact statement, and they aren't notified. So then if the DA opens their file and sees that the victim has requested to speak at sentencing to give that victim impact statement, they would know to continue that hearing and not violate the victim's rights by proceeding otherwise. So these are the best practices. So we'll go through moving forward the rights that have to be requested. So unless the victim says, hey, I have this right, it's an upon request right, I'm requesting it, you know, it's basically understood that the victim is not interested in it unless the victim says that they do want these rights enforced. And one of those rights is the right to confer with a prosecuting agency. And I think at this point, it's really good, a good point to talk about the goal of victims' rights. It's about fairness in the process, not the outcome of the case. So when I say confer with a prosecuting agency, I'm not saying that the victim has the right to actually prosecute the case or tell the prosecutor what to do. The prosecutor is not the attorney for the victim. And a lot of times that's a huge misunderstanding. Victims think that the prosecutor is representing them. Unfortunately, that's not the case. The prosecutor represents the state of California and will act on behalf of the best interests of the state of California. So when I say the victim has the right to confer with a prosecuting agency, I mean, they have the right to get information from the prosecutor. They have the right to give input to the prosecutor. They have the right to be notified about a plea deal that's going to be offered before it's offered. That's what I mean by confer, to communicate with the prosecutor. The prosecutor is still the driver of the criminal case, the prosecution side, and the victim is a participant in that process, but not the driver. That's still the prosecutor and always will be. Victims have the right to request to be notified of public proceedings. So unless a victim lets somebody know that they want to know what's going on with the criminal case, that they want to get a notification of hearings, that they want to be there, they're not going to be notified. So it's really important, if the victim wants to know about these public proceedings, if they want notice, that they have to request it. And it's really important for you to be educating your clients about that if they do want to participate. Victims also have the right to be heard at any proceeding at which the right is at issue. This is also upon request, so they can speak directly to the judge if the right is at issue, but that's another one of those upon request rights. Victims also have the right to request to receive a copy of the pre-sentence report when it's available to the defendant, except those parts made confidential by the law. And this is important for victims, especially as they're putting together their victim impact statement. If they want to use some of the information that's provided in that pre-sentence report, you know, and talk about that, they have the constitutional right to get a copy. Victims also have the right to get information about the conviction, sentence, place and time of incarceration, or any other type of disposition of the case. And this is really critical for the safety of our victims, right? A lot of victims are concerned for safety for valid reasons. They were victimized by either a family member or even a stranger who can find out where they are. So they want to know where this person is incarcerated, how long they're incarcerated for, etc. And if the person is sent to custody under CDCR, we talked about that 1707 form, but if they're in county custody, if the offender's in county custody, they would have to contact their own county agency that oversees that. In Sacramento County, where I am, it's an agency called Sirens. Other counties use Vine. Other counties have their own system. So if you want to know in your county which agency oversees notification for county jail, please give us a call at 1-800-VICTIMS and we'll be happy to provide you that information. But victims have to be proactive and have to request that information. And this has been really critical in COVID, in the COVID era, where, you know, especially with domestic violence cases, folks are getting arrested, the abuser's getting arrested, and then the victim has no idea if and when this person's going to be released, and they have no idea who they should contact to get that information. So please, please, please make sure that they're connected with that agency for their protection. Victims also have the constitutional right to have their safety considered and to provide information, provide basically a victim impact statement at parole proceedings. Once again, that 1707 form with CDCR, they do not automatically get victims' contact information when they take custody of an inmate, which is what you would automatically think, well, if they get custody of an inmate, they'll know who the victim is. That's not the case. The only way they get the victim's information is if the victim fills out that 1707. What we're seeing across the state, unfortunately, is sometimes victims aren't told at the end of the case that they need to fill out this form. So they're finding out that the perpetrator was released on parole from a newspaper or from a neighbor or from a friend. So we don't want to put victims in that situation. We want to make sure that we are being proactive and letting them know of these rights. You have the right to participate and to get this information, but you actually have to take the step to get that information. So those are the rights? We talked about the automatic rights. We talked about the rights that have to be requested. So you may be thinking, well, great, victims' rights are, alive and well in California, all 17 of them. Unfortunately, that's not the case. The current state of these rights in California is that they're illusory rights. And it really breaks my heart when I hear victims tell me, I wish I didn't have these rights, because knowing that I had these rights and that the system completely ignored it made me feel like I was a victim of the system. These are just words on teeth. They're not worth the paper that they're printed on, is what a lot of the victims feel, which is really tragic, right? If you are a victim of a crime, as service providers, what we need to be doing is empowering victims, letting them know that they're important, that they're a critical part of our process, that their voice, their input, their participation is important for our justice system. We don't want to be sending the message that it's okay to ignore them, and it's okay to ignore their rights and trample on them because they don't have power. So there's a lot of confusion and uncertainty about, who should be specifically notifying the victims, about the request piece, how is the request going to happen, etc. So it's really up to each and every one of you to make sure that these rights become meaningful. And rights become meaningful when people are asking for the rights, but if they're not aware that they have these rights, they're not going to be asking for them. So it's important to make sure that victims are aware of these rights, that courts enforce them. So victims have to be aware of them and they have to be asking for them, for the courts to enforce them, and that the system routinely complies with them. And that's going to take a lot of education for our judicial professionals or judges or prosecutors or defense attorneys about victims' rights, to make sure that it becomes part of our culture, right, in the justice system. And think of Miranda rights, right? At the beginning, we did a poll on Miranda rights, and a lot of you guys were familiar with Miranda rights, and that's because it's part of our culture. So we want to get to the point where it's the same with Marsy's Law, where everybody is educated on Marsy's Law, where victims are aware, they're asking for them, and the judges and the courts are complying with these rights and making sure that they're protected and enforced. And really the ramifications of ignoring these rights are huge. We talked about the system-wide implications initially at the beginning of this presentation, but there's a lot of frustration and hurt that victims feel if the rights are ignored. They feel marginalized, frustrated that they were never told, frustrated that their rights aren't being complied with. They feel like they're a victim of the system, as we've talked about over and over again, and just a general sense of injustice, right? Can you imagine being a victim of a crime and then feeling like the system that was supposed to bring you justice ended up making you feel like a victim? So we want to make sure that we avoid that. And really the only way to do that is to make sure that victims are provided with information about their rights and that they're empowered as they're going through the criminal justice system, so that they feel like they have a voice and a choice in the process. And the only way to make this happen and to make this as a reality is for all of us to work together. Each and every one of you in this webinar today are more expert now on Marsy's Law than most people in California. So I'm going to rely on each and every one of you to make sure that your clients are aware, that your colleagues are aware, that victims have constitutional rights in California. We want to be proactive with these rights. We don't want to wait until victims' rights are violated to say, hey, well, I had this right, and it was violated, so how can we fix this? We want to make sure that victims are aware that they have these rights, that they're asking for them at the outset of the case, and they don't wait until it's too late, right? And let's think about the issue of restitution. So if I'm a victim and I have a ton of financial expenses, victim compensation will cover $70,000, but I have $250,000 in medical expenses. So at the beginning of the case, should be thinking about, okay, restitution, I need to request restitution. I need to make sure that it's set as a dollar amount and not as a TBD or to be determined. So what steps do I have to take to do that? Who can I contact to make sure that that happens? And we need to be making sure that our victims have that mentality, that we have that mentality as we're helping them. Okay, let's think about who I can connect you with to make sure that you are getting the help that you need to make sure that your rights are protected. And we're going to do another poll now, our last poll. So when you think about victims' rights, if one of your clients feels like they have a possible violation of their victim's rights, who would you refer them to? Would you refer them to their bar association lawyer referral, their local legal aid, the district attorney's office, or you're just not sure? And this isn't something that a lot of people have thought about in terms of victims' rights violations. And if there is one, well, who would I be referring to? So I wanted you guys to kind of think about that in your practice. And could we go ahead and launch the results? All right, perfect. So about 48% of you guys said the district attorney's office, which in general would be a great place to refer victims for information about the criminal case. However, remember I said the district attorney does not represent the victim. And sometimes the victim's rights and the victim's interests are different than the prosecutor's interests, right? The prosecutor's representing the state of California and are acting on behalf of the state of California. And I'll give you an example. So for example, if the district attorney wants to offer a plea to the defendant and the victim does not want that, does not agree with that, victim understands that they don't control that, but they want the judge to hear why. So if the victim calls the district attorney's office with a complaint about that, they likely wouldn't be able to, the DA wouldn't ethically be able to provide them with feedback or advice. They can't give them advice because they're not representing them. So you want to make sure in cases where you have a possible Marsy's Law violation that you're connecting victims with a victim's rights attorney, somebody who will be representing the victim and will be looking out for the interests of the victim only as their attorney. Local legal aid is a great guess. However, unfortunately, as I talked about earlier, a lot of attorneys are not familiar at all with Marsy's Law. And a lot of local legal aids will provide assistance with civil legal matters, so housing, some family law, employment issues, but not victims' rights issues, so not Marsy's Law assistance. So you want to make sure that you get familiar with those agencies that actually provide criminal justice advocacy for crime victims as they're going through. And we can go ahead and remove the poll. So in creating a referral, please call us at the 1-800-VICTIMS hotline. We have a set of attorneys, victims' rights attorneys that can provide you as a service provider with guidance on victims' rights, or also refer you to folks in your county that can provide this is such a specialized area of the law, and there just aren't a lot of attorneys doing it. And sending victims to the wrong agency will end up being very frustrating for them. Because if I call legal aid in, most of the counties across California, they wouldn't even know what I'm talking about when I say Marsy's Law violation. So it's important to keep that in mind. And it's also important to, we talk about the district attorney's office and the DA advocates, the district attorney advocates. It's important to understand that they work as part of the law enforcement team at the district attorney's office, and they don't have any confidentiality with the victim. There are laws that mandate them to relay information to the DA and then to the eventually to the defense attorney under a law called Brady that will completely obliterate this idea of confidentiality. They don't have confidentiality, so it's important at the outset of the case, or even for you in your practice, to make sure that victims understand what your role is, and if you do have any type of confidentiality or privilege with victims. And that's to avoid frustration by the victim. If I'm talking to my victim advocate at the district attorney's office and I relay something that is very personal that, may have some implications on the case, but I didn't intend for it to be known, and then I find out later that the advocate was required by the law to tell the DA, and then the DA was required by the law to tell the defense attorney, that would be very frustrating for me as a victim. So it's important to make sure that victims are aware of roles and confidentiality at the outset of dealing with them. And victims' rights attorneys have standing to be there with a victim in criminal court. They have standing to be there as the representative of the victim, only to represent victims' interests in the criminal case, only to protect their rights. We're not there as the driver of the criminal case, that's the prosecutor. We're not there to prosecute the case, that's a prosecutor. We're just there to support and make sure that victims' rights are protected and that victims end up feeling empowered as they end the criminal case, and they feel like they were respected as they went through. Unfortunately, there is no constitutional right to appointed counsel, so the victims can connect with a victims' rights attorney, either who works pro bono or they can pay them. There are a few attorneys that will charge for their services, but we offer our services pro bono. And it's really important to talk to victims when things don't go as planned. You know, the criminal justice system can be so frustrating for victims. Sometimes charges aren't filed. Sometimes charges are dropped. Sometimes a plea is offered and the victim doesn't feel like that's fair. So it's important for victims to get connected with a support system, mental health providers and others that can help them, you know, understand that this is not the end all for them. The criminal justice system is not something that they control. They're a participant in it, but it does not have to define them or what justice is for them, and that there are other options in the civil arena. And really, I cannot highlight this enough. Each and every one of you really have the chance to make a tremendous difference to any victim that you deal with. Each and every one of you can be that person that empowers victims with the information about this right, with these rights, to make sure that they're protected and that they feel like they're part of the process and they end up feeling empowered at the end, ready to move on with their life and not devastated and re-victimized by the process. So please don't hesitate to contact us. I have informational slides here about some of the things that we do at the Victims of Crime Resource Center, and I'm out of time, so I'll let you guys read that when you get the slides. But please don't hesitate to give us a call if we can be of any assistance. We provide research assistance for service providers, so please don't hesitate to reach out to us if we can be of any assistance. And I'd like to thank Nicole and her team for putting this together and allowing me to come and share information about Marsy's Law.
Oh, thank you, Miriam. We so appreciate it. And I know that you could go on for hours. So I want to assure everyone that you're going to get this recording as well as the slides early next week. So before we transition to questions, I have an exciting thing to draw your attention to. So for those of you who were children of the 80s, you may remember the Choose Your Own Adventure books. And so today we are launching our Choose Your Own Adventure January webinar. All of you may remember Paul Greenwood, who kicked off the series for us, the renowned district attorney from San Diego. And he has provided us 3 options for our January webinar. And you, our community of elder justice warriors, get to select which topic you want us to present to you. So if you'll click the link that Christy just left in the chat, you will be the first to vote. Voting will be open through December 31st, and then we will take your selection, and that's what we'll learn on in January. So please take a moment. We're still going to do questions, but while you're waiting, go ahead and click that link and vote. Let us know what you want to learn about. So now we're going to transition to questions. And Miriam, that was a lot of information, but I think we had some real interest. And so just a clarifying question from Maria around the rights that need to be requested. Who do they need to notify that they're requesting their rights if they want to be notified about hearings?
I'm sorry, I was muted. That's an excellent question. And we recommend, although there are some rights that need to be requested, we recommend that victims request all of their rights. And we actually have a template request letter that you can reach out to us to get. But the request to be notified should go to the victim advocate and the DA who's overseeing the case. And make sure that that request goes in writing, right? You want that paper trail to make sure that you have proof that you made the request. But excellent question.
So when you have those requests, do you need to, like, during normal life, do you need to drop it off at their office? Do you need to mail it and keep the receipt indicating that it was delivered? What kind of records should you keep to support that request? That's
an excellent question also, the delivery of that request, because we've seen that a lot of verbal requests, get lost in translation, as they say. So we recommend that you send it certified to the victim advocate and to the DA, and then to call them and confirm or send a follow-up email to say, hey, I sent this letter. It was delivered to you on this date. I'm just confirming that, it's in my file now and that you're aware that these rights were requested. There is one county, Nicole, it's Nevada County in California, that actually there's a form that has to be submitted to the judge by the DA's office or the victim's rights attorney that lets the judge know which rights the victims requested. That's only one county in California, but if we can get all of the counties to have a system like this where the judge is checking in with the victim to see which rights the victims want requested, that would be great. But until then, please send a certified letter to the victim advocate at the district attorney's office and the DA and make sure that you have a record of them confirming receipt.
Okay. So in that same vein of that great practice we hear from our friends in Nevada County, What are the things, what are other good practices you have seen from either district attorney's offices or local or state policy that we can take and apply in our own areas?
Yeah, that's an excellent question. I think really making sure that victims understand what these rights are and what they mean. Because if you're just handing them a piece of paper, is that really meaningful notice? If I'm getting a paper of legalese that I don't understand. So I've seen some counties where the victim advocate will actually go through the rights with the victim to make sure that at the beginning of the case, to make sure that the victim knows what these rights are. Okay, so do you understand you have the right to restitution? Here's what restitution means. And we have a ton of informational publications that we can mail for free on these topics, right? So this is something that you can have in your office and you can hand to your victims. And our publications are written in plain language. It's important to make sure that things are written in plain language so that the victims that you're dealing with are understanding the information that you're providing. So going through the rights, making sure that they understand what these rights are. And some victims want nothing to do with the case. So also respecting where they are in the process, right? And meeting them where they are is really important.
Absolutely. And in that same vein, I was surprised to learn that you were saying that the victim advocate may have to share some information. And our friend Bob from Solano asked, so are the statements from victims automatically or mandatorily included in pre-sentence reports, or is it just optional?
I think it depends, right? And so when I was talking about victim advocates, so because they're part of the law enforcement team, there's, from the Brady case that says that, victims have to relay information. If a victim relays information to the advocate or to the DA that has implications on the outcome of the case, that information has to be relayed to the defense attorneys. And I've seen some counties in California where the blanket rule is anything that's relayed to the advocate has to be relayed to the DA, and then the DA then decides which information to relay to the whether or not it meets that standard. So we just have to be really careful at the outset to let victims know, okay, we're about to talk. I just want to make sure you understand the limitations of what I'm able to do and whether or not there's that confidentiality, so that they won't be frustrated as they're dealing with me.
Right, appreciate that. So we have two final questions. One's kind of really sort of nuts and bolts, which is, can you speak to the reimbursement of surveillance cameras as victim compensation?
Yeah, that's perfect. So as long as you're a victim of a qualifying crime, and that's threat of injury or physical injury, there are a few crimes where emotional injury is enough, but majority is threat of injury or actual physical injury. Then CalVCB will reimburse for security cameras, and they are the payer of last resort. So if the victim has other types of coverage. For security cameras, you probably won't have any other coverage, but for like medical or mental health. But for security cameras, we were able to get reimbursement for security cameras for victims that we've applied for, victims of domestic violence, victims of elder abuse, as long as you can show that there's that fear there. The California Victim Compensation Board is an excellent agency that helps provide reimbursement for up to $70,000 for those types of expenses.
Okay. So we have an elder justice warrior who asks, they say they saw the documentary on the gym doctor who abused a number of girls for years. The girls gave victim impact statements over 3 days. What specifically can you do as an advocate or conservator to help assure a victim is heard?
That's an excellent question. So the first thing would be to make sure that the victim makes that request, because unless they make a request to be heard, they're not going to be heard. So make sure that your advocate at the district attorney's office and the DA who's overseeing the case knows that you want to participate in sentencing by providing a victim impact statement. And then really spending time explaining what a victim impact statement means and what information they can include in that victim impact statement. And that's something that a victim's rights attorney can help with. A lot of times the victim advocates at the DA's office can provide information, but if you ever have any questions about these types of issues, please either call us at 1-800-VICTIMS or have victims call us at that same number. We'll be happy to provide information specific to the issues that your clients are facing.
Okay. So before we sign off, I like to ask our presenter a question. We're 9 months into a pandemic. We as victim advocates often hear really hard things, but continue to persist, as you said, the hope for the future. So what is it that you do as someone who's worked in this industry for a very long time, do to maintain your hope and work towards a more just system for victims?
Something that I do, and we do hear a lot of really horrific things. I mean, I do try to practice self-care and make sure that to check in with my team to make sure that they're practicing self-care. We do a retreat once a year to make sure that we give ourselves space to heal from everything that we're dealing with, because, you know, we're suffering all from vicarious trauma. But for me, I mean, what really keeps me going, Nicole, is the knowledge that I'm making a difference in somebody's life, that because of the information that I'm providing to this victim, they feel empowered, they feel important, they don't feel re-victimized by the system. And that's what attracted me to this area, and that's what's going to keep me going here, because no matter the pain that I feel by hearing these stories, it compares, you know, very minimal to the trauma that they're enduring. So being able to help is really, for me, energizing.
Mm-hmm. Thank you. Well, Mariam, I know that you've informed so many of our practices here in our organization, and I appreciate that, the opportunity to continue learning from you, and I hope others have as well. As a reminder to everyone, you will receive the PowerPoint and the recording, and we will be doing some additional recording tomorrow to get to the questions that we weren't able to get to today. I want to thank everyone for joining us today. I want to wish everyone a healthy and safe holiday season, distance from other households. And I hope to see you back here in January on the 21st, where we're going to hear from Paul Greenwood. As a reminder, use that link to vote and let us know what you want Paul to talk about. So thank you so much to everyone for joining us. Thank you to all of our sponsors and planning partners. And I wish everyone a safe and happy December.